Case number 10.
Morning, Your Honors.
Morning.
Please the court. Samuel Carpel on behalf of the appellants.
Before you start your arguments, can you just explain to us in layman's terms, physically, what is happening here?
Yes. So the respondents purchased the Henry Street Basin. It's located in Red Hook, Brooklyn.
Speak a little closer into that mic.
And it's been determined by the federal court that Gowanus owns the property.
Yes. Yeah. The respondent owns the Henry Street Basin, which includes bulkheads that abut the appellant's property. There's bulkheads on the east side, on the north side, and on the west side of it. And it's owned by the respondent. And we maintain that when the respondent purchased...
I'm sorry, and just for further clarification, the south side opens into the bay.
Yes, it opens into the bay.
Okay.
Yes.
But what I'm asking, physically, you're alleging that the respondent's bulkheads are deteriorating and need repair. So physically, what is happening to your property?
Okay. So there's water that is now ebbing and flowing through the bulkhead, which causes erosion to the soil. And just above the bulkheads, there's upland. It's a walkway. It's around 20 feet wide.
That's your property?
Yes. And then there's a large warehouse, approximately 100 square feet, out of which the appellant operates his business. And the bulkhead is deteriorating. The respondents have refused to do any repairs whatsoever to the bulkhead.
So physically, what is happening to your property? Sinkholes,
Yes, so
collapse?
there's, right now there's sinkholes on the deck. Yes, there's sinkholes. And it's going to continue to get worse if the respondents don't repair the bulkheads.
What would happen if you did it?
Well,
Have to get permission from them to do it?
the appellants and other parties have tried to repair the bulkheads, and every time a party tries to repair the bulkheads, they're faced with a lawsuit by the respondents. The appellants tried to repair it in 2007. They were faced with a lawsuit. The owner of the property prior to the appellants in 2004 tried to repair it. They were faced with a lawsuit. In 2004, Hess Corporation, which owned at the time the property on the southeast portion of the Henry Street Basin, they tried to do some work on the bulkhead. Then they were faced with a
So when
lawsuit.
he comes up, he's going to say that you failed to state a cause of action, and so we ought to get rid of this. And what is going to be your response to that?
Well, we maintain that because they purchased the Henry Street Basin, that includes these structures, they have a common law duty to maintain the structures in a condition such that it doesn't cause harm to the appellant's property. And in addition, they have a duty imposed by the rules of the City of New York, specifically it's Section 2-04A of Title 66 of the Rules of the City of New York, which states that the owner of a bulkhead must maintain it in a safe condition.
Do you have standing to make that argument, or is
Yes,
that for
Your
the
Honor.
city?
Yes. No, I believe that we can, it's not a cause of action that we're asserting under Title 66 of the Rules of the City of New York. Rather, we're asserting that there's a duty under that rule and is a common law duty. And what we're alleging is that there's a private nuisance cause of action as well as a public nuisance cause of action.
So the lower court, the Supreme Court dismissed this on a theory that only the state could bring
Right.
this, but
Yeah, and
did anybody argue that?
No one argued that, and they relied on the 1901 Court of Appeals case, which we maintain doesn't address the issue in any way.
Because you're not arguing lateral support.
No, we're not arguing lateral support. If the damage had to do with lateral support, it's totally irrelevant. Or if the damage was flooding into the warehouse, it's irrelevant. What we're arguing is that they have a duty. They failed to maintain the bulkhead in a safe condition, and they're obligated as a property owner and as the neighboring property owner to repair it, which they have failed to do for over a decade now.
So you're also arguing that you have demonstrated the elements of a private nuisance?
Yeah, of a private nuisance, yes, because the appellant is caused to lose use and enjoyment of his property now and possibly in the future. Particularly, there's a large warehouse out of which he sells light bulbs, and to the extent that the damage continues and there's damage to the warehouse, then there's really substantial commercial damage
But do you have measurable damages at this point that can be quantified?
At this point, no. At this point, we don't have measurable damages that can be quantified. There's damage to property right now. I don't have a figure as to what it would cost to repair that. But as far as the cost that the respondent would incur in repairing the bulkheads, even if that's substantial, it doesn't absolve the respondent from its duties, from its common law duty, and from abiding by the rules of the City of New York. And
But then it doesn't prevent you from getting injunctive relief either. You'll be entitled to some.
yes, which we're seeking. We're seeking monetary damages and injunctive relief. Yeah, so we're seeking both.
And how do you meet your burden on a mandatory preliminary injunction?
We maintain that we do, because there's damage caused every single day by the basin, which is a respondent's property, and
Yeah, but revisit that. Oh, sorry. I'm sorry. I finished that question because you just raised something for me, because you said you're seeking monetary damages and injunctive relief, and if you can't get either or, it's either they enjoin because there's irreparable harm, there's no way of you getting, So if you're going to say I'm entitled to monetary damages, you're saying give us a certain amount of money, so that you can't say that and also say injunctive relief. So am I missing something here? So tell me what.
No, Your Honor, I respectfully disagree. I believe that we can assert a claim of damages with respect to the damage that has already incurred. And with respect to injunctive relief, the respondent, we're asking
Prevent future damages?
To that. Okay.
yes, to prevent future damages.
Okay.
And we maintain that the trial court erred in relying on the Court of Appeals case in stating that the action must be brought before the Department of Environmental Conservation.
Going back to the injunction, you're seeking affirmative injunctive relief to compel them to repair,
Yes, we're seeking
right?
them to, yes. We'd like to compel them to begin the application process and to begin the work.
So you're seeking to prevent continuing damage?
Yes.
Ongoing damage? Is
Yes.
that what you're seeking?
Oh, absolutely, yes. There's ongoing damages, and the bulkheads continue to deteriorate because the respondents refuse to make any repairs to it, and prevent the appellants and all other parties who have tried to repair it from conducting any type of repairs. And so the lower court, in relying on the White case, erred. Certainly, the appellant has the right to bring a court action against his neighbor, which we have done. And in addition, the appellant has a claim for public nuisance because the northern section of the Henry Street Basin abuts a park that's owned by the city, and the city and the public have riparian rights, and they have the right to access the basin. And to the extent that the bulkhead continues to deteriorate, there's substantial likelihood that some type of harm could occur to individuals using
But then it gets back. That's your argument for the public nuisance?
for public nuisance.
And I go back to Judge Scoy's question then with reference to that. You have standing to raise public nuisance since you have to affect
I
a
believe-
substantial amount of individual. Is that your cause of action?
Yes, I believe that we do have standing to assert a claim for public nuisance because we have shown that there's special damages. The special damages are unique to the appellant because there's substantial property damage that
And you're not arguing negligence, so that's why you're able to do that.
Wait, I'm sorry, I didn't hear you.
And you're not arguing just simple negligence. You're arguing
Right, yeah, we're arguing...
private or
Yeah,
public.
we're arguing special damages that are different and totally unrelated to the damages that would be caused to the general public.
And you rely very heavily on the City of New York versus Gowanus, Justice
Your Honor.
Miller's case. How does that case?
Right, so that case involved the very same respondents, the very same Henry Street Basin, and bulkheads located on the north side. And in that case, there was no issue in the trial court or before this court about whether the appellant must, which was the city must, I'm sorry, the respondent in that case was the city. There was no issue regarding whether the city must first bring the claims to the state. There was no standing issue. Of course, they could bring a civil action against their neighbor, which is the respondent. The lower court in that case ordered the respondent to repair the bulkhead and remove a fence which prevented public access to the basin. So insofar as there was no issue in that case regarding compelling the city to first bring the claim before the New York State Department of Environmental Conservation, similarly in this case, the appellant must be allowed to proceed with a court action, which is what we were trying to do.
What happened as a result of that case? Were there repairs?
I believe the portion of the fence that blocked access was removed, and I believe whatever portion of the bulkhead held it up was repaired. So now there's access to the public.
Thank you.
Good morning. Good morning, Your Honors. James Maloney for Respondent, Gowanus Industrial Park, Incorporated.
So, counsel, why do you not have the duty as described by appellants?
Because this is not an adjacent land, Your Honor. This is water. And what appellants are seeking here is protection from the water at our expense. They are alleging that the tide ebbs and flows through this bulkhead and causes them damage. The tide ebbing and flowing is not the work of our corporation. It is the work of the sun and moon's gravitational effect. The lateral support argument, counsel says it's not being made, but that's what they're seeking. In addition to protection from the water is lateral support of the land. If I analogize this wall that I'm looking at here before Your Honors to their property, I'm standing over here on our property. In between is this Henry Street Basin to which we have title to the submerged lands. Now that bulkhead, at least parts of it, are built on our submerged lands. So yes, we have not wanted interference with it. If it's not done right, it could be a problem. Have they come in and sought a declaration as to what they may do to solve their problem? No, they want us to protect them from the water at our expense of $8 million. So what they could do is build another bulkhead behind that. Go ahead.
So you're still saying that there's a question as to the ownership of the bulkhead?
Parts of it, because if you look at the pictures in the record on appeal, there are pages, pages 248 and page 250 show that the prior owner of their lot, Mr. Catucci and American Stevedoring, his companies, they began to do some of their own work. And that was the subject of a lawsuit by Gowanus Industrial Park to stop them. At that time, there was a question of title. There was a lengthy side history here about the title. I think Your Honors are familiar with it. But as of 2012, the federal court, Judge Gleason, found that we do, in fact, have title. But at that time, Mr. Catucci and his companies began to excavate the bulkhead, and there was a lawsuit. So the parts that were rebuilt there farther back are resting on the parcel that belongs to appellant. Much of the bulkhead still is resting on our parcels. The point I'm making is that they could.
But aren't you still saying that they are not allowed to come in and do anything to the bulkhead? You don't want that done?
Well, I think there should be some cooperation so they don't knock stuff into the water and mess up the channel with rocks falling into the water. I mean, it's a navigable channel. So if it's to be done, it should be done properly. The problem with Mr. Catucci's
How would
work
you know
is it
it's
wasn't.
done properly? I think you seem to be going both ways here. You're like, okay, fine, you could come in and you can't come in and do it, but it's not our obligation to do it, so it has to remain that way.
No, there's a distinction I'm making, Your Honor.
Okay.
The bulkhead that's resting on our property, analogize that to the wall in front of you here.
Right.
If you were to build your own bulkhead where you're sitting, a little farther back on your property, that would be fine, and it would protect your property from the water. If this bulkhead deteriorates, you've got your bulkhead resting on your property. That's the point I'm making.
And you're saying that the deteriorating bulkhead would not affect them at all because they would have built the bulkhead.
Build their own on their own property behind it. That's
so with all these questions outstanding, why are you entitled then was this a summary judgment here?
3211.
3211.
Okay.
Because they haven't stated a cause of action, Your Honor. This is an equity case, and they're seeking essentially the kind of relief that applies to landowners where one excavates the adjacent property and denies lateral support. The Court of Appeals has said that doesn't apply. The court below said the state may have the power to do that. Okay. There's a more recent case that's never been, I don't think, addressed by them. In a footnote in Kim versus City of New York, it's mentioned on my appellate brief at page 7, there's a footnote that says that the lateral support doctrine does not apply to sunken or submerged or underwater lands. Because really, it's not us. We didn't remove the adjacent support. It's a waterway. We bought this property that includes the submerged lands, and it has some very old bulkheads on it, yes. But for us to say that we have a duty to support the landowner on the opposite side and protect them from the water. They're a waterfront property
Well,
owner.
haven't they stated a cause of action? They're entitled to just state a cause of action. They're not just they don't have to prove it at this point. You may be right in the final analysis, but on this record, can we just say they didn't state a cause of action?
Well, if we say there's a cause of action for this, an equity cause of action for an adjacent landowner to seek this kind of relief, we're opening the door to an awful lot of new causes of action, I think.
Well, because you're saying the question of duty is a question of law, right? Whether there's a duty or not, I think what you're saying is if we find there's no duty, then there's no cause of action.
Well, that's right. We don't have a duty to protect them from the water.
And you're relying on what for that statement? You're relying on Kim and you're relying on the White case?
Well,
Or
and
anything
we're
else?
also relying on the fact that there's no prior case that says we do have such a duty. I mean, when you're talking about adjacent landowners, usually the duty arises when somebody excavates. They excavate, they take away the lateral support of the adjacent landowner. That's not the case here.
I know, but I think the thing here that is interesting is that what's raised is the nuisance and not necessarily a negligence claim.
But are we creating the nuisance? And there's an interesting question here. You raise a really good point, Your Honor. And, of course, as you say, you always raise a really good point. But the claim that they're making is that we have a duty to repair the bulkhead. Now, their own engineering report talks about an alternative. It's called riprap. And there's an illustration of riprap in the record. I'll get to that in a minute. But their own engineering report says, and I believe it is at page 45 of the record, that their cheaper alternative would be to build riprap, meaning rocks that slope, back away from where the bulkhead now is. And it would involve removing the bulkhead, true. But that would cost less money. But what would happen then? They would lose 8 feet of their property because the bulkhead protects them without losing any property. The bulkhead is vertical. The riprap extends horizontally 8 feet.
Let me
They're
ask
not
a
seeking a declaration. Yes, go ahead.
Let me ask appellate question here. Why don't you guys just sit down and talk about this? Because it seems to me, from what you've said here, that if you sit down and have a realistic discussion, you can figure out what's going on here with this. You seem to have quite a lot of the answers.
I think the problem, Your Honor, is that this action seeks to put the burden and cost of all this work on us. And for them to do it, they'd have to spend the $5 million to build the riprap or $8 million to do new bulkheads. It's in the engineering report that they submitted. So the problem is, if they can get us to pay, when you're talking about money like that, it's a lot cheaper to litigate. So that we tried settlement talks in the court below. I don't think it's appropriate to go into too much detail, but the picture of riprap that I show, I believe it's on page 237. 238, I'm sorry. Page 238 is a tiny little photo. It shows riprap. And I mentioned in there that was proffered by myself at the February 10th, 2016 conference. That was when I was proposing maybe they'd want to do this at their expense.
And that was 2016, so costs are probably higher today?
I don't know. I'm not an engineer, so I won't guess. Most costs tend to go up rather than down, so I suppose that's fairly accurate.
Who uses this waterway?
Sorry?
Who uses this waterway?
Well, our property side has some use of the basin for navigation. Theirs does not. And in fact, that raises an interesting point about their standing under that city ordinance. And by the way, the city ordinance was never mentioned in the complaint. But the city ordinance, I don't want to reiterate all my arguments in the brief, but I have a whole section about why they don't have standing under the seminal case, Shee versus Big Flats, to bring an action because they don't use the bulkheads for navigational use. The reason you have a bulkhead, by the way, is not to shore up the land. You could put riprap there for that.
But only you answer that question from Judge Mastro, because I'm interested in knowing who uses it too.
Oh, we do. We don't use their bulkhead, of course, their side, but we use the channel, the Henry Street Basin, And they've even put plenty in their brief about our use of the Henry Street Basin, or in their papers below, I should say. But they don't use the navigational aspect of this body of water. So they don't use the bulkhead for navigational purposes. The reason you put in a bulkhead, for example, if I have a ship coming into the Henry Street Basin, I want to tie up over there. Well, I can't have riprap, which is a bunch of rocks sloping. I need a vertical surface so the ship can come alongside. That's the reason the bulkhead was put there initially. This was originally navigationally used waterfront property in Brooklyn. Now it's land over there that happens to be waterfront, but they're not really using that.
Do you have real-life boats that go through that waterway?
Well, it's a dead end, but they can go in there and dock. They don't dock on that side. And I'm making your side.
One's big like a ferry, or the smaller?
The Lou Jane
Like
is a
cargo
concrete
boats?
boat that's on the other side. I don't know the depth. It would really depend entirely on the depth of the Henry Street Basin. That would determine how big a vessel could go in there. That is actually one of our concerns, is that if bad work is done on that bulkhead over there and rubble is knocked into the Henry Street Basin, it rolls across, and it now makes the Henry Street Basin less navigable. And it's quite expensive to bring rocks up.
That's where I was going with this. Isn't this a hazard to navigation, or couldn't it become a hazard to navigation?
The bulkhead? Probably if it
it's
deteriorated
eroded,
and
falling-
fell in enough, conceivably. I mean, that's a whole different question. I don't see how the standing to bring the action would be on their side. We're the owners of the underwater parcel, so
Right.
it would be a hazard to navigation that harms only us.
It was mentioned in the record that you might have plans or had plans or wish you had plans to create like a large floating restaurant, kind of big entertainment. Is that?
There have been so many plans with this property over the years, Your Honor. I hesitate to even conjecture their entire scope. There was talk about docking the United States, the Big U, the famous ocean liner there. That never materialized. You know, waterfront property in Brooklyn, all kinds of things can happen with it. All kinds of ideas can get generated. Right now, there's no grandiose plans that I'm aware of. And I guess that wouldn't really be relevant to the issue before the court. The key here, though, is that there simply isn't a recognized duty or cause of action to compel us to protect them from the water. They
counsel-
happen to be I'm sorry?
Counsel,
I think
I'm sorry.
I suppose that the argument that you have a responsibility to repair the bulkheads at the cost that you indicated, I'm assuming that the cost that you have attributed to this project would be in the nature of $8 million?
Well, actually, that's their number. That's in their engineering report that came in with the order to show cause. Page 10 of the engineering report, which is page 45 of the record, shows a list of immediate remediations that should be done, one or the other. And the $8 million is the cost of repairing existing bulkheads. That's in a tabular form under 4.2 on page 45.
But
this is their document.
All right. So that argument would also suggest that not only would there be a responsibility to repair the bulkheads now at that particular cost, but there would be a continuing obligation to maintain the bulkheads at whatever cost would be attached to the continuing obligation.
Well, that's right. If they win this, they win a lifetime pass of free protection from the Henry Street Basin, so that we have a duty to maintain that bulkhead
In perpetuity, perhaps.
in perpetuity, right? So that's a good point. I mean, when does it end? And I guess in theory it doesn't. If they have the right to, if we have a duty to maintain this bulkhead now, we have a duty to maintain it forever. And that means that the waterfront property owner on the opposite shore gets a free ride on protection from the elements. I mean, you carry it further a little bit logically, and if the weather gets worse and climate gets worse and water comes up, global warming, maybe we have a duty to raise the bulkhead too. It becomes like Holland. We have to, put
What governmental entity has jurisdiction over this body of water?
Well, probably several. The Army Corps of Engineers comes to mind because of their jurisdiction over navigable waterways. New York's own Department of Environmental Conservation has a great deal to say about waterfront property, and in fact, it's my understanding, and I don't want to go beyond the record, but it's my understanding that if you want to put in riprap, you have to get their approval. But they like riprap generally because it's environmentally favorable. It's a lot of surface area, oxygenates the water, that sort of thing. But those two come to mind immediately, one federal, one state. I mean, to some extent, the Coast Guard has some jurisdiction over navigable waterways as well. There's quite a lot of entities, and the city, of course. The city has their own rules, and they have that rule that's been cited now by appellants, which really is meant to protect navigable waters and commerce. It's not meant to protect landowners adjacent to it, but, you know.
Well, since you conceded that there's some, and you both have, that there's some disrepair there, has there been any of these agencies involved in looking at this situation that kind of exists?
I don't think there's been any interest by the agencies. I don't think the repair is serious enough to any of the city's interests. The only one, the case that was mentioned, of course, is the one at the, I guess the best analogy would be over there. In that corner, there's a park where the court officers are sitting. And we had erected a fence because there was a bit of a danger of trespassers coming down and, you know, maybe drowning themselves or something in the water. And then, could this be our problem? Yeah. So we put up a fence. The city said, take it down. The city did have standing. The city won. So the fence is gone. I think there were some repairs done to the bulkhead. But that case was not primarily about the bulkheads. That case was about the fence. Nothing like that exists here. I think I have said everything I need to
Well,
say.
and the Supreme Court didn't really address the issue of duty, just said you have to go to the state, correct?
That's true. The Supreme Court may have gotten it right in part for the wrong reasons. But the key is that the Supreme Court found that there was no cause of action in equity here. And I think the thing to keep in mind most of all is that equity causes of action are a bit more open-ended than legal ones. First, you need the duty, and I would say there's no duty. But also, let's look at the equities involved. We know that they could build their own bulkhead inland.
But I don't think first you need a duty. I think we would do that analysis if we were going to go down the road of there's some negligence here. But I think if we were just going in a nuisance situation, duty is not the first thing we'd look at.
Okay, so let me assume that that's the case,
Okay.
and we may not necessarily agree, but we don't have to disagree. Even if there's no duty, the question then is, what should be done in equity? Well, it seems to me that the landowner ought to have to put up something of their own to protect their property. They shouldn't just get a free ride that this bulkhead that was there 100 years ago and is now starting to fall apart has to be repaired in perpetuity by the owner of the underwater portion. That doesn't seem very fair. And so an equitable result might be an order that says...
And why should you get to use you get the benefit of what they're put up? Because obviously if they put up something on their side, it's going to strengthen what you're claiming is or they're claiming maybe disrepair on your side.
Well, I don't think that that what they do will have any effect positive on the basin.
Well, if my wall right here is wobbling, and Judge Mastro comes and puts up his great, nice wall, his nice wall is going to help my old wobbly wall. So they're going to say, well, if we're supposed to be putting something up, why should we put something up that helps you?
Because it's up there primarily to help you. I mean, the only interest
But
we
not
have...
predominantly to help
See,
you.
we're good neighbors, though.
I see that. That's good. But the thing is that anything that you do over there has very little effect on our interest unless it causes rubble to go down and choke up the channel. If you start putting junk on the bottom of the Henry Street Basin, then it becomes less navigable. That hurts us. Other than that, we don't care what the view is. You can have riprap. You can have an inner bulkhead. You could come up with something new. Doesn't matter so much. I think an equitable result would involve that property owner, the appellant here, doing their own work, and if they wanted to go in and get a declaration as to what their rights were with regard to destroying our bulkhead, that would be a much more appropriate cause of action than putting all the costs on us. Thank you.
Okay. Thank you.